The next speaker is going to be presumably a big head on the screen, Philip Santo, instrumental in the updated RICS guidance, professional standard, as it has just been declared in the last couple of days. Philip contacted me yesterday to let me know. I think he was quite excited about it. He did say that he refers to it as a guidance note in his presentation, which was recorded before the good news. So let's see what he has to say.
Good afternoon. Thank you for the invitation to speak today, and I'm very sorry that I'm not with you in person. I've been looking forward to this conference for a long time, and I'm very disappointed not to be with you today. I'll shortly be retiring, so I'm particularly sorry not to be able to catch up with friends and colleagues today. Still, such is life, and I'm grateful for the Property Care Association for facilitating this recording so that I can share some thoughts on what has happened since the Select Committee inquiry into Japanese knotweed. And I'd like to do this in 3 stages. First of all, I'm going to look at the Parliamentary Committee inquiry, what led to it, what followed, how the new assessment process has developed, and what the response to the guidance has been, and then finally to look at some challenges which lie ahead. Back in 2019, the House of Commons Select Committee on Science and Technology held an inquiry, and there is your leader on the left, Steve Hodgson, being questioned about that, along with some other worthies, and then some members of the Property Care Association here also facing the same grilling during that parliamentary session during February 2019. And the House of Commons committee provided a report which emphasised things that we all know well, that the beliefs of the public and the media about Japanese knotweed are unduly exaggerated, and they place an excessive burden in the residential property market due to nervousness amongst buyers, sellers and lenders. They made a number of recommendations. The most important one probably is to remove or replace the former 7-metre rule with something more nuanced and evidence-based, describing that as a blunt instrument. But first, before we go on to what followed that inquiry, I just want to think about why the inquiry took place in the first place. You'll recall that back in 2012, the RICS published the information paper, Japanese knotweed in residential property, with the famous 4 categories, 1 to 4, based on the 7-metre distance of an infestation from a building or from the boundaries. And effectively, that's worked well in terms of the property market being able to work. But even early as 2015, when the Property Care Association held its first invasive weeds conference at the Vale Resort in South Wales, we realised that it was a bit too conservative and we needed to refine it. And we talked then about what we could do to improve things. And it was decided to put together some research, and we also had the opportunity there to visit Dan Evans' research project into remediation in South Wales. Very interesting day there to see that research which was going on. But in the following year, the members of the Property Care Association and child surveyors and valuers contributed to research being undertaken by Leeds University and ACOM into what they were actually seeing and finding on site in terms of the realities of knotweed. Also during 2016, Steve Hodgson himself spent a considerable amount of time on the information paper, redrafting pages of it and trying to bring it forward into a meaningful way. But things didn't develop at all, and most of that ended up in a basket, unfortunately. And I was at RICS, meanwhile, trying to persuade the powers that be to move forward on this. But the committee I was reporting to, unfortunately, had other priorities. And right through 2017, although I kept telling them the research was on its way and that the knotweed needed to be updated, nothing happened, unfortunately. Finally, in 2018, Dan Evans published his report on the best ways to remediate Japanese knotweed. And also in 2018, Mark Fennell, Max Wade and Karen Bacon produced their influential report on the impact of knotweed compared with other common plants, buddleia and trees and ivy, and that proved very influential in moving things forward, but not, unfortunately, at the RICS, who still sat on things until the parliamentary inquiry was announced and RICS finally had to come to the table. So the committee held its hearings in 2019, and the RICS was committed itself to providing an update. They established a leaders forum and then a working group with significant number of PCA members present. You won't be able to read those names, but they're on the guidance note if you want to see who was involved in that process. And they produced their objectives and then went forward, started to work on what the guidance note would look like. The most important thing was that the new guidance had to establish a straightforward and, as far as possible, objective classification to replace the 7-metre rule. But this needed to be useful to enable valuers and surveyors to provide a preliminary assessment to give initial mortgage lending and pre-purchase advice. That is the primary purpose of the guidance note published by RICS, and the design of the assessment process was focused in that direction. It does have other uses, it is used in other areas, but that is the primary objective. Then in 2020, coronavirus struck and things rather ground to a halt, sadly. But towards the end of 2020, Risk and Policy Analysts, on behalf of Defra, published a report which had been commissioned by the Parliamentary Committee, and they made a number of recommendations, a number of findings. But in terms of the guidance note, one of the key findings or recommendations was that there should be a focus on management and control rather than eradication. And so that is where the focus came. Instead of talking about the risk of knotweed, it was how an infestation might be managed when it was found in a residential environment. Then during 2021, the real nuts and bolts of the information of the guidance note got put in place. There were detailed and lengthy communications between me at RICS primarily and Peter Fitzsimons at PCA primarily to get together and to make sure that the guidance note met the needs of surveyors and valuers, obviously, but also the remediation industry as well. I'd like to pay tribute to the work and support that Peter contributed to that process. And at the same time, Peter was putting together the PCA guidance directed at surveyors and valuers to fill in gaps which were present in the RICS paper in terms of identification and remediation options. When the papers had been drafted, it went out to consultation, and there were a series of extensive briefings to key stakeholders, as well as just putting it out into the public domain. So invitations went out to the media and the public, and also the Law Society, as well as obviously the remediation industry, lenders, surveyors, valuers, for comments and contributions to the development of the guidance note. And when the responses came in, they were collated, fed back to the working group, revisions were made, and the document was finalised. And then the RICS edited the paper and prepared it for publication. And finally, in January 2022, the paper was published, and strangely enough, exactly 10 years to the day, March the 23rd, after the original information paper was published, the guidance note came into effect. At the same time, the Property Care Association published their guidance note for professional valuers and surveyors with such useful information in, including costings and for site plans, which fell outside the scope of the RICS paper, which provide valuable information for valuers. So this is the assessment process, the flowchart, the decision tree, which you'll, I'm sure, be familiar with if you work in this area. And on it, we have 4 decision points. So it's still on site, a relatively straightforward process, only 4 decisions to make, leading to these 4 management categories. And I've been asked to explain briefly how the management categories came about and how they developed from what we had originally. So I'll just spend a couple of minutes doing that. The objective of the assessment process from the RICS perspective was to make it suitable for valuers and surveyors during a general inspection of a property when they're looking at a lot of other things as well, and knotweed is just one peripheral item. The assessment had to be straightforward. The management categories had to be straightforward to define and to report. And they had to be easy for clients, the lenders and the public to understand. They also had to be in a logical format for the remediation industry. They needed to allow the remediators to address the concerns of valuers and surveyors, to meet the needs of lenders when they were issuing mortgages, and to satisfy homeowners and purchasers that the Japanese knotweed issue was being appropriately dealt with. So here we've got serious damage to a boundary retaining wall. You can see the knotweed dead stems along the top of the wall there. It's caused major movement to take place. This would have been formerly a category 4 infestation, the highest of the categories. This is now defined as a category A action because knotweed is present, but it's caused severe damage. So there'll be expensive remediation required, which is going to impact on value. On the other hand, this would also have been a category 4 infestation where we've got knotweed right up against a building, but actually it's causing no damage. So it doesn't need to be rated as the same level as the damage to the boundary wall. So this is now categorized as the amenity is being affected, but no damage is being caused. So this is category B action. Arguably, you might say this is not even affecting the amenity. It ought to be a category C, but that's a decision for the valuer on site. It would have been a category A infestation, these 2 examples here, where we've got infestations affecting the amenity, and where we've got amenity being affected, this is category B action. The reason these would have been a category B, a category 3 previously, is because they were within the boundaries. Simply within the boundaries was a category 3. Now here we've also got an infestation tucked away in the back of this flower bed, also a category 3 previously, but actually not causing damage, not affecting the amenity. So this is now rated as simply present, category C, manage. And then we've got category D, offsite. If it's offsite, report it within 3 meters. But there is now admittedly an element of subjectivity, especially regarding amenity. So those are the management categories that we've come up with, and the guidance note was launched out into the wide world, and we sat back waiting for fireworks. And what did we get? Nothing. Silence. And we listened, still silence. Everything ticked over. After a couple of weeks, I sent out questions. What's going on out there? No significant issues, very quiet. Major lenders have welcomed the guidance, and absolutely no problems. Even recently, I heard back the policy seems to be working, we're not getting any noise. I sent out a question to the Surveyor Hub community with 4,000 members. Has the guidance led to any changes in attitude or perception amongst the stakeholders? And was I overwhelmed with answers? I got 1 reply. I would say no. I did get 4, 5 likes. So I think we can conclude that it's done its job. and I think we're going to be with it for a little while yet. So thank you for your help on that. Everybody has contributed to that process. We can regard it as a success in terms of not adversely affecting the market, and I hope looking forward we're going to be able to see the market gradually becoming less wary of knotweed. It's not going to happen overnight, but I hope the stigma will gradually diminish, the impact on value will reduce. So let's look at some possible challenges. I just want to deal with three briefly. First of all, thinking about what Karen was saying earlier on about invasive species, assessing risk, can we use the language of this guidance note when we're looking at other invasive species? Damage caused, immunity affected, simply present but not doing anything else? Is it off-site within a particular distance? Would this apply to bamboo? Could we apply this to bamboo, for example? Or what about other invasives? Are there additional reasons for caution or reporting? For example, the damage to health or the risk to health from giant hogweed. But in terms of valuers and surveyors, they need to be aware of what the risk species are. They need to be able to identify them in order to report on them and to understand the significance in order to help. So there's a challenge there for the invasive management community, if you think valuers should be reporting, to get that level of detail to the valuers so they can start to provide reports. Secondly, changes to the Law Society TA6 question. Section 7.8, is Japanese knotweed present? Yes, no, don't know. Is this a reasonable or appropriately phrased question? If not, what should it focus on? Personally, I think it's inappropriate to ask simply, is it present? There's additional help to lawyers about knotweed being concealed beneath the ground level, but that's no help to a homeowner. We don't explain what dry rot is and then say to homeowners, is dry rot present? What we ask them is, have you done any dry rot treatment? Have you built an extension? Are you aware of disputes with your neighbours? That's the way this question should be phrased. At the moment, it's a recipe for litigators, unfortunately, and I think it's inappropriate that when somebody innocently answers no, and then later on somebody removes a garden shed and finds knotweed at the back, there's no defence in law to that inadvertent response. I know as much about knotweed as most house sellers, and even I would answer don't know to that question when I sell my house. I'm not going to risk a no, even though I know that there's not any. The trouble is, if a change is desirable, which I think it is, where is the motivation from change going to come? The Law Society won't change unless prompted. The RICS have got good communications with the Law Society, but when I've left, I don't think there's going to be anybody, I'm not aware of anybody there feeling motivated to push for this. So it's going to require some lobbying if you agree that a change is appropriate. And then finally, potential issues with expert reports. Under the previous process, 7 meters was a yes/no question. It was a question of fact, whereas, as we've said now, the assessment process is partly subjective, but the assessment is primarily the remit of the valuer or the surveyor. Don't forget, that's what the assessment is about. It's advising lenders, should they be lending, should they be making a condition on the mortgage advance. That is what it's primarily for. And there can be difficulties if you as a remediator are asked to produce an expert report and then you make your judgment about whether amenity is affected, and then the valuer comes along and makes a different judgment about whether amenity is affected, and you've got two experts on the same side of litigation with different opinions, and that's the sort of gap that will be exploited by barristers. So just be wary about that. I mean, I just wonder, is it ever really a need to provide an assessment? You're not reporting to lenders, but I do understand that homeowners may be interested in your opinions. But if you do give an opinion as an assessment, just be careful how you frame it in relation to what a valuer may say. The PCA have provided some very useful and helpful information on that, and I refer you to those and just suggest respectfully that you make sure that you fit in with that. And so that's it, ladies and gentlemen. We've looked at the Parliamentary Select Committee inquiry, what led to it, what was recommended, what followed, how the new assessment process developed and what the response has been, and some possible challenges ahead. And I just wanted to say a couple of words in conclusion. I'd just like to pay tribute to the unstinting support of the Property Care Association and Steve Hodgson during the dozen or so years since the Property Care Association took on this, what was then a new role. And also to Sue Uttridge, who provided the support back in those early days and who I'm sure has gone to organise an excellent conference today. Thank you all, and it's been a pleasure working with you. Thank you.